This is another bad neighbor case.
If you thought the What the Hales was bad, this is equally, if not worse.
If you move into Florida, there's some things you gotta know. It's not all sun and sand, there's a place you just can't go. When that 3 years off the charts, the neighbors are a fighting. You can't get any peace or quiet. They're screaming day and night in Levy County. Oh yeah, it's a criminal bounty. Oh yeah, call the sheriff, he can't help you, and the judge will try and fight you. Ain't no way to live a good life down there in Levy County.
Come on, motherfucker! I'll kick your fucking teeth right through the back of your goddamn skull!
There's a woman with some turtles who screams and yells all day. They're all sick and in need of shelter, but the fishing game says it's okay. She's got a kid that ain't hers, and she's locked her in a shed. But CPS don't care about nothing, even slaps around the head in Levy County.
Have anxiety over the roof.
It's a criminal bounty. Oh yeah. Call the sheriff, he can't help you, and the judge will try and fight you. Ain't no way to love your neighbor down there in Levy County.
Same judge.
Same lawyer.
Same lawyer. Randall Shockett is the lawyer for the Gosney family.
There's a man who hates his neighbor from the day that they moved in. Plays his music all day long, no one can stand the din. He scares the poor old widow who lives across the way as he shouts, "You motherfucker, don't you look at me that way."
Oh!
Levy County,
Motherfucker, I ain't got a goddamn thing in my hand!
criminal bounty. Oh yeah. Call the sheriff, he can't help you, and the judge will try and fight you. Ain't no way you'd ever catch me down there in Levy County.
Another family falls victim to Judge Grudge.
Okay, so we have here in the circuit of the 8th Judicial Circuit in Levy County, Florida. Oh, it is Levy County. Holy shit!
Oh, Jesus. There you go. That answered that question in the second line, didn't it?
Careful, you got nails and stuff. Don't go in here.
Harley, get out of there. Harley, do you see the nails? You're going to fall and get one right in your eye.
Let's go! Let's go, motherfucker! I will fucking kick your goddamn teeth through the back of your fucking skull! Do you comprehend me?
Good morning, good afternoon, good evening. Good evening, Jeff. How are you?
I'm fine. Do you comprehend me?
I love that part where his voice cracks. Do you comprehend me? It's so funny. It's so funny. Okay, good morning, everyone. Welcome back to the show. I am your host today, Megan Fox, medium smart journalist and online commentator and sometimes comedian unintentionally. Today I was late. I'm sorry that I was so late. But I actually did. Those of you who said I was doing my hair were absolutely correct today. I had a problem. I was working on the bingo card so diligently, Jeff, so diligently that I got lost in the moment. And then what happened?
Somewhere in time.
And then what happened was that I went into the bathroom, looked in the mirror, and went, "Oh my God, there's a rat's nest on my head," and I had to comb it out and wet it down, and then try to dry it again. And yeah, that didn't work out so well. So
What's weird is it was an actual rat's nest. That was a weird one.
Little baby mice like scurrying out. Yep, it's my hair's fault. So you guys can probably check off the Megan talks about her hair on your bingo card. I need to pin it. I didn't do that yet. Let me pin. It's a new bingo card today.
The bingo card.
The bingo card.
Oh, okay.
Bingo.
Hi, chat. Just keeping you occupied while she does the bingo thing.
All right, there we go.
Like and subscribe to us.
Have you pinned?
We're doing
your
better
bingo?
than yesterday.
Yeah, we're not going to have 35 minutes of bullshit because we can't get the stream working. That was embarrassing.
Yeah.
But, I already got a comment on that said I had to come over here and watch it on your channel because Jeff cut out the best part. I told you to leave it. I told you it was funny. But no.
But it's sad that the people think that was the best part of our show. The part where we were lost and confused and didn't know what we were doing.
There should be hair on the bingo. I put the hair on the bingo. Did it not work? Did it take
no hair on the bingo? Sorry.
Oh, sorry guys, no hair on the bingo today. All right, sorry. Just check off your free space instead.
That's the free space is the hair space because she's always going to talk about the hair.
It's basically the same thing. Yeah, basically the same thing. Okay, we have a new bingo card. Let's go over it because we're going to be reading a motion today. And all right, here we go. Share.
Emotional damage. Get it?
Wait, I have that button.
I know.
It's not working. My Stream Deck's not working. That's bad news.
You are a meathead.
Mine is.
Oh, no. I have to quit the Stream Deck and then reopen it. Maybe that'll help. I don't know why it's not working. It's annoying. Okay. All right. Let's look at the bingo card. Today's bingo card, Gosney v. Griffith. We've got blam, blam, blam. 911 call. Timestamp. I plead the fifth. Judge insults lawyer. Muppet voice. Judge interferes in another case. Judge pontificates. I feel like pontificates should probably be the free space. Dog snore. Motherfucker. Ore tenuous. 15 minutes. Sunset. Religious tyranny. Dick hard. Judge reads Farmer's Almanac. Lewd acts. Calendar fuckery. Inappropriate dog toy, which will probably be tomorrow since we can't have Doggo Cam on this stream today. So that one's you're probably not going to get that today. But unless, Jeff, you happen to see that happening and you can catch it on film. Bias. Judge don't care. Judge lies about schedule. Griffith's no-show. Are you recording me? Okay.
It's going to be very hard to get a bingo today, since that we're just reading motions.
I don't know. I went through the motion. These things should be in there. So
Look, I prepare. I take pride in what I do. She's just admitted on stream. She just goes through the motions.
And I will tell you, I went through at least 15 pages of it. 15 pages, Jeff, to find these bingo squares.
Oh, interesting. Wow.
So let's see. Did my Stream Deck?
Emotional damage.
There we go.
All right. We did a little reboot. We got the StreamYard up and working. We can have a button war if we need to. This is good.
I don't think we ever need to. I think it's a
I always need a button war.
Want. I think it's more of a want than a need. I think Maslow would disagree with our hierarchy of needs if there's a button war on it.
As usual, I would encourage all of you, if you are not subscribed to the Legal Vices over here, you need to go to Legal Vices on YouTube and subscribe to his channel, mods. Make sure that his link is somewhere in the chat so that my chat can go over and subscribe there. We are simul-streaming on both channels. So if you are here from Jeff's chat, welcome. If you are here from my chat, welcome. We are going to have a great day today. We're going to go through the second motion to disqualify Judge DeThomasis from the Gosney v. Griffith case. Now, I have to shut down all these windows. Why do I have all these windows up? This is a problem.
While she's shutting down those windows, I just want to say exactly what she said, but back at her. If you're over here, you go over there and make sure you subscribe to her and like her videos. And mods, please drop the Megan Fox link. And we'll see how we get through the day. I said we're reading through stuff here. It hopefully will be entertaining. If not, it'll just see how long it takes me for. I'm living the high life tonight, Megan. I'm living the high life. I'm enjoying a 17-year wild turkey bottled in bond bourbon.
That sounds pretty good.
Oh, it's exquisite.
So I do have an announcement to make before we get started.
What's your announcement?
This just happened. This is another reason why I was late, because I was communicating with Viva Fry. So Viva Fry has decided to have me on today, right after this stream. So I do have a hard out at 12:15. So
Can we mark up Dick Hard on the bingo card now?
Nope. Oh, okay. I did not say Dick Hard. I said hard out.
All right.
So this just happened, and Viva Fry. Oops, wrong. What am I doing? I'm trying to get I'm trying to get this screen. There we go. So at 12:30 today, I will be appearing with Viva Fry on his channel. And apparently we're talking about the Russiagate hoax, which I have no knowledge of whatsoever. I don't know.
Does Viva know that you don't know anything about this?
He does. He does. That's not really why I am going on. I am going on. Here's his second card, the LawTube lawsuit. We are going to talk about the thumbnails lawsuit against Jeremy, Larry, and DJ Radis and George. And then the secondary topic is some Russiagate thing that I have absolutely no knowledge in, have not followed, but I will do my best to pretend like I have. Does that sound good?
Sounds decent.
So I told you guys, I tried to tell the lawyers who just got involved in this latest lawsuit, you're not going to like what happens after this. Because once you start suing people in LawTube, like Larry, like DUI guy, like anybody else, all the LawTube or LawTube adjacent people are going to start picking up the story. And I think Viva's got a channel with over 400,000 subscribers on it. And it's just going to get bigger and bigger until you wish you had never done it. So that's just...
Well, I think some people are now beginning to wish they hadn't become involved.
You think? We had a interesting show last night, didn't we? Some people are definitely getting concerned that they're involved, especially with the threats of lawsuits flying around. A thing that I don't like, although I like covering them. I like reading about it, but I don't like suing everybody. Suing everybody is it gets ugly. All right. Let's see. We got to pull up this. So tune in for that at 12:30. I'll be headed over to see Viva Fry after this. Okay. Where am I at? Here we go. Second motion to disqualify. Look, only 11 minutes of bullshit, Jeff. We are cutting this down. This show is going to be just, skinny. It's a skinny show today. It's
now 12 minutes and 3 seconds of bullshit. 4 seconds, 5 seconds.
Why is this so big?
That's what she
That's what she
Beat
said.
you to it.
Damn it.
Extra large and extra hard.
Bet you don't have that one. Not many people have Ben Shapiro talking about penis size.
Don't try to be funny, will you, meathead?
You got it. You got Archie Bunker.
I did. Just for you.
That's fantastic. All right. Here we have and Jeff and I are going to take turns. We're going to switch off as we read through here. Make sure your bingo cards are open and you're paying attention. In the Circuit Court of the 8th Judicial Circuit, because this is serious business. Pay attention, class. Get your pencils out and get ready to pay attention. Brenda Gosney and William Gosney, plaintiffs versus Philip Griffin and Kimberly Griffin, defendants. Plaintiff's second sworn motion to disqualify Circuit Court Judge Grudge Craig DeThomas's. I did not have dog bark on my bingo card. Dog snore.
This mother effer over there has not made a noise for about 22 hours.
That motherfucker back there is not real.
You did what? You were quiet for like a day.
I did not have dog bark on the thing. Your dogs are getting feisty in their elder years.
She just sat there for 22 hours without making a sound.
She likes to be part of the show.
She
likes to be part of the show. So, you just keep it up, Straubs. You just keep us entertained. The plaintiffs, William Gosney and Brenda Gosney, the Gosneys, not Steve Gosney, by and through undersigned counsel file their second sworn motion to disqualify Circuit Court Judge Craig DeThomas's from the above captioned case pursuant to Section 3810 Florida Statute Rule 2.330 of the Florida Rules of General Practice and Judicial Administration, and set forth below their legally sufficient grounds for such disqualification and relevant precedent in support thereof. All right, Jeff, you may take over. Okay.
Statement of facts and the case. The Gosney's second motion to disqualify, because again, this is the second motion. The first one was denied in court minutes after it was written, while the Shockett team was drafting the first motion to disqualify, Judge Grudge was drafting his dismissal of the motion, which prompted. We didn't get the date on this, did we? This is February 5th or 5th. I hate these dates. Is that May 2nd or February 5th?
It was e-filed May 2nd.
Okay,
is what
May
it
2nd.
says.
All right. So this is May 2nd of this year.
That is actually Mr. Fox's birthday.
Cool. Yeah, so this is this year. We've nearly a year I guess more than a year. A year and 1 month has transpired since the first motion to disqualify was filed. Right. But this is interesting because as Megan just mentioned, we don't have the final order, do we?
Yes, we do. It's attached as Exhibit 1. And it's hilarious.
We should read that.
Should we read it first?
I think we should start reading that, yeah.
All right. So where we left off was what had happened was the judge was taking it under advisement. He kept them there, almost to sundown, violating the Sabbath for Randy, kept them there for 8 hours in what was supposed to be a 1-hour hearing. And then he said he was going to take it under advisement and come back with his ruling. Well, here is his ruling. Yeah, let's read this first.
I'm dumb, Megan, in case you didn't know. I said it was a year and a month. It was only a month. For some reason, I thought the hearing was from last year. I'm stupid. Never mind. It's only been a month.
Okay.
Sorry.
Corrected. You stand corrected.
Right. By myself. So is that
order
really correct?
On petitioner's motion to dissolve injunction? You can start this.
This cause, having come before the court upon, this is the magic words, by the way, before the court, motion to dissolve final judgment and of injunction for protection against repeat violence filed 2/8/24, filed on behalf of the respondent, and this court having held hearing on 4/12/2024 and having also reviewed and considered the petitioner's response to said motion filed on 4/11/24.
I'm surprised he didn't put a timestamp in there.
And the entirety of the testimonial and other evidence presented at hearing, and in evaluating the relevance, materiality, credibility, persuasiveness, and other thesaurus words and or lack thereof of such evidence, and in consideration of applicable law, finds as follows.
A final judgment for protection against repeat violence was entered on 9/11/19 against the respondent, with the court determining that it remain until further order of the court.
Although the final judgment, as pronounced, provided such relief for co-petitioners William and Brenda Gosney, there was never a petition filed on behalf of Brenda Gosney, and she never provided this court with sworn testimony regarding a factual basis for the relief she was granted.
Is that a joke? Does he mean somebody else's court? Because we saw her on the stand giving her testimony.
Scroll back up there in just a minute here. There was never a petition filed. Now, see, remember, they submitted the petition, and Gosney had signed it twice. Mr. Gosney had signed it twice, and he made fun of he made fun of Shockett for that, and he said, "Okay, do you want to go back and correct it, or do you want?" He said, "I want to correct it."
So even though he corrected it, he's still harping about it?
Apparently. And if he did correct it, then she did file the motion. So I'm curious.
This is unbelievable. I think we may have a would this be judge insults lawyer? Is he insulting the lawyer here or insulting Brenda? I can't tell. So I guess we don't have one yet. All right. To obtain the relief of dissolving the injunction, the party seeking such relief has the burden of establishing that there has been a change in circumstances. This requires the movement to demonstrate that the scenario underlying the injunction no longer exists, so that continuation of the injunction would serve no valid purpose. See Alkery v. Alkery. Further, as a general rule, permanent injunctions, which remain indefinitely in effect, may be modified by a court of competent jurisdiction whenever changed circumstances make it equitable to do so. Baker v. Baker, because a reasonable fear of imminent violence is a legally necessary predicate to the issuance and extension of an injunction, it follows that a reasonable fear of imminent violence is also necessary to justify denying a motion to dissolve an injunction that is otherwise supported by the requisite change in circumstances, and mere speculative feature of future violence cannot be enough to justify the never-ending existence of an injunction. Oh, really? He kept a never-ending temporary injunction on Jeremy Hales for a year without a hearing.
That's a temporary one. This is the
This
temporary
one was a
can last
permanent
year.
one.
I know.
My God, this man is such a walking contradiction. Subjective fear.
I think that was a Muppet voice.
Oh no! I guess it was. Who knew that I was going to do Muppet voice? Subjective fear is not sufficient to maintain a permanent injunction. It must be objectively reasonable. Yeah, but this guy's not objectively reasonable. So whatever he thinks is reasonable, it clearly isn't. Because a reasonable person doesn't act like him. Since the entry. Oh, this is you. Number 4.
Yes, it is. Since the entry of the final judgment 4.5 years ago, there have been no findings of any violation of the terms of the injunction. The respondent has complied with the special condition of seeking mental health treatment and provided proof to the court. The respondent served 24 months of probation with adjudication withheld concurrently with the injunction without any alleged violation of the terms of that probation / community control ever being filed. That the respondent has recently moved from the petitioner's neighborhood and the respondent has placed his property on the market for sale.
Documentary evidence revealed that there have been 8 calls to law enforcement involving the respondent and or petitioners as relevant parties. Of those 8 calls, 2 were the predicate incidents that gave rise to the injunction being entered. Of the remaining 6, only 1 resulted in a sworn complaint alleging a violation of the terms of the injunction. That case resulted in the office of the state attorney filing a no information on 4/1/24. But I would like to take this moment to remind you what a shit job the Levy County Sheriff does in making a case against violations of restraining orders. Because in most cases, as we've seen, they're like, no video, it didn't happen. You don't have video? It's not on video? Did you have someone robbed your house? Well, did you get it on video? Someone stole your car. Well, did you get it on video? Like, that's their answer to everything. Eyewitness testimony doesn't mean shit in Levy County. So just reminding you that. Number 6, Jeff.
Okay. I think we should do 6. Then we should read some super chats before we get too far.
Oh, yeah. Okay. Oh, I didn't know we had a bunch coming in. Fantastic.
Of note, the petitioner's response submitted to the court the day prior to hearing, alleged in subsection 6 as follows. Isn't this subsection 6? Anyway, concurrently, there are 2 active criminal cases currently pending against Mr. Griffith for violations of the 2019 injunction, with one of those criminal cases having just been opened on January 26, 2024. Case number blah. If that assertion was established at hearing, it would have given significant weight. If that assertion was established at the hearing, it would have been given significant weight. However, should be period, however, comma, as with other allegations proffered by the petitioners at hearing, this averment is inaccurate and misleading.
Oh. Judge insults lawyer?
That kind of sounds insulting.
Yeah. You think? He just accused Randy of misleading the court.
As stated above in section 5 of this order, at the time this response was prepared and presented to the court, the state attorney had already filed a no information in case blah 10 days prior, a fact readily ascertainable. Inexplicably, despite advancing the averment that another second active criminal case was currently pending in hearing, it was ascertained such reference was to an incident occurring on February 6th, 2024.
He just will not let it go. Every time Randy makes a mistake, He will not let it go. And then he writes about it in his orders. He not only goes off on him in court, but then he writes about it in his orders. This guy is so insufferable. Do I have an insufferable square? Damn it. No, I don't. In a separate ongoing lawsuit between these same parties, styled as William and Brenda Gosney v. Philip and Kimberly Griffith, a deposition of the respondent's wife, Kimberly Griffith, was scheduled to take place on 2/6/24 at a neutral location, the law offices of a local attorney unaffiliated with the litigation. As stated in the respondent's motion under review and established by clear and convincing evidence. The attorneys for the respondent contacted the attorney for the petitioners on 1/19/24 and specifically informed petitioners' counsel that the respondent would attend the deposition in person as he had such a right under the rules of civil procedure.
Oh my God, this is going back to that BS.
Oh yeah.
The attending the deposition crap.
Yeah. Yeah, I mean, it's incredible. Additionally, respondents' counsel requested petitioners' counsel to confirm that the petitioners would be attending via video conference. The evidence at hearing revealed that despite petitioners' counsel representing that he would get back with a response to assure that there would be no possible contact between the respondent and the petitioners at the deposition and to determine whether there would be a need to seek a protective order, as was done previously when the respondent provided his deposition. Counsel, this is the biggest run-on fucking sentence I've ever seen in my whole life. We have not seen a period since way up here.
Additionally.
I mean, my God. Counsel for the respondent clearly gave advance notice of where and when the respondent would be during the deposition. Finally, a period. It would be axiomatic. Oh my God, this guy. I just want to stuff socks in his mouth. I want to like, stop. Axiomatic. Do you have to use words like axiomatic? Which means clearly true, by the way. If you didn't know what it meant, it means clearly true.
I must confess to have typed the word axiomatic in a letter earlier today.
No, you did not.
I did.
Is this something that lawyers do?
Yes.
Stop it.
We're paid $400 an hour. We do this shit.
Stop making people use dictionaries to read the shit you write. It's insufferable. It would be axiomatic to believe that petitioner's counsel had his primary responsibility the need to advocate for the preservation of the injunction ostensibly due to his client's alleged imminent fear of the respondent. What the hell is this word salad? Like, if I to break down this Jeff, make this sentence in like 4 to 5 words.
It would be axiomatic. I have to read it again. It would be axiomatic to believe the petitioner's counsel had as his primary responsibility the need to advocate for the preservation of the injunction ostensibly due to his client's alleged imminence. It's clear that the lawyer needed to advocate to continue with the injunction because of imminent fear to his client.
Yeah, that's a little better. That makes it a little clearer. Yeah. The way he wrote it, it's like it's impossible to even understand what he's trying to say. Given the unrebutted evidence that the respondent would be present at the location of the deposition and at the time it was scheduled to take place, one would reasonably conclude that the petitioners could have been anywhere other than the location of the deposition on 2/6/24 and would never have been at risk of any contact with the respondent.
See, again, this is something we talked about when they brought that up. It's not illegal for the Gosneys to attend the deposition. In fact, they have a right to be there. Mr. Gosney had a right to be present. Whether they got their wires crossed or not doesn't matter. It is the Griffiths' duty to stay out of the way of the Gosneys, not vice versa. He shows up, you should go, well, shit, I guess we're going to go into a different room, or I guess I'm going to go home and go and zoom in.
This is funny. Keith says, "Dear ChatGPT, please make this simple sentence read as if written by a lawyer so that it could be read to mean many things." All right, let's get to some super chats because apparently this paragraph is going to go on for several pages.
Oh, Lord. Yeah.
Fallen Hero, thanks for the Dala super chat on, is that Is that my channel? I think that's my channel.
Yeah, it is you.
He's my member. And here's for Jeff.
Fiery Red Podcast member for 5 months. How's it going, brother? Hope you're feeling decent today. Good morning, Jeff, Megan, and all. Glad I woke up early enough today. Still here and fighting. Keep it up, brother. F cancer, F cirrhosis. Y'all are awesome. Thank you very much, sir.
Definitely F cancer. Definitely. Unhung hero, thanks for the 2. The time you 2 waste is over the roof.
I have anxiety over the roof.
It's true. And for Jeff.
A hard on is better than a hard out.
And also for Jeff.
Woo-hoo! Thank you very much, Aussie Wombat, for the 5 Legal Vices memberships that were gifted. It was a while ago, so I can't scroll up to see. Oh, yes, I can. It's still on there. KT, Colo Mountain Girl, Bad Duck, Kimmy, Mark Stewart, and Lisa Ann. If you got one of those, make sure you give Aussie Wombat a super special thanks.
And for Jeff again.
Yay, look at me. Hey, Ty Sticks, what's up? Sending you my super chat today. Yes, I get it today.
Nice.
Megan got it yesterday.
That's nice and fair. Connie B, thanks for the 5. If Levy County can't wear video, they shouldn't require video. Be a detective, for fuck's sake. Yeah, they don't have body cams either. So, but they require you to get it on video. We can't require them to wear body cams, though. I see how this works.
And then they go, "Are you recording?" And then you get in trouble.
Suzanne, thanks for the 20. No buttons from Megan equals no real stream. You were both awesome, and I appreciate everything I learn and all of the laughs. Well, we appreciate you, too. And Unhung Hero, again, Duggar women see periods more often than this.
Wow.
And for you,
Wow.
Jeff.
Sonny or Chris, holy run-on sentence, Batman.
Yeah, it's insane. My English teacher would not appreciate that. Jeff, this one's for you.
DJ Radis, what's up? It's not funny. Well, it is because it's not me. What's up, DJ Radis? Megan. Thanks, Megan. I'll be sure you get this $2. Megan, you need some scrambled pancakes with ketchup.
He made, DJ Radis made the most hilarious satires parody song yesterday about Slug's pancake making session.
Well, I was actually thinking of just doing a video to show you how to I protein powder pancake.
Oh, I think that would be helpful.
But
I
didn't hear the song though.
There are some kids hanging out in their mom's basements who really could use some help with that.
Yeah. I didn't hear the scrambled pancake song. No.
Oh, it's good. Well, we'll have to play it. Maybe when we get bored and we want to take a break, we'll play it later. It's really funny. He made a great video and a song about the scrambled pancake. And
sorry, I thought you were done.
No. I just want to encourage Slug to make more of that shit. That was funny. That was fun. I agree. I loved that every minute of it.
And also over on Cash App Land, Kay Adams. If you're here, if you're not, I'm sorry. I'll send you a personal message. I just got a notification that Kay Adams sent a $20 Cash App thing on Monday. And the damn notification just arrived.
Isn't that weird?
But also, I think it was because D What just dropped 60 on Cash App. It says for release the hounds. That I can't release the hounds today, but we'll release the hounds tomorrow, straight out of the gate. Promises. So that's where I'm sitting with all the outside of YouTube-y things.
Okay, and it looks like I'm good on the Cash App Venmo front so far. I haven't gotten any notifications. I don't know. That doesn't mean they're not out there, though.
That's what we call passive-aggressive demand to send some.
Yeah. No. No, I'm good. You guys have been so generous. You guys have been so generous this week and during this series. I just think you're wonderful. Only send it if you have it. Don't send it if you don't. But definitely hit the like button and the subscribe because that doesn't cost you a thing. That's for darn sure. And if you are subscribed or were subscribed or think you're subscribed, you better check because YouTube is asshole and they unsubscribe people regularly and they claim that you're a bot. Are you a bot? I don't think so. So make sure that you check your subscriber level. All right. Here we go. Where was I? I was getting back into this giant paragraph. I'm going in
very
the
axiomatic.
totality of the circumstances. Did I put
magic
that on the
words.
bingo card? No, damn it. The totality of the circumstances.
Magic words. Those are magic law words.
Oh, wait. Maybe I didn't read this part. I didn't. While
we didn't read it.
while that is not to say that they had any legal obligation to stay away from the respondent, nevertheless, in terms of evaluating their alleged ongoing fear of imminent harm from the respondent, any assertion that it was the respondent who made contact with the petitioners on 2/6/24 lacks credibility. Jeff, does the respondent have to make contact? I don't think that's what the no contact order says. It says he can't even show up somewhere where they are. That's considered
he's
contact.
a ghost. He doesn't exist. He's not even allowed to stare in their general direction.
He's not allowed to stare at them. He's not allowed to sit in a lawn chair on his own property facing their house, according to the judge. Like he's not allowed to do that. So it doesn't require that he make contact with them. It only requires that he ends up in a place where they are, and then he needs to turn around and leave. I mean, you might not like the order, but that is the order. I mean, for God's sake.
I mean, you can say it's a dick move to do what he did, but it ain't illegal.
No. Okay. The totality of the circumstances of the 2/6 incident refutes any claim of such fear. So he's now putting himself into the mind of the petitioners, and he can tell that they're not scared.
Well, see, I completely disagree with that. Just because he showed up for the deposition where he knew the guy was going to be doesn't mean he wasn't scared. It's in a law office surrounded by people. His lawyer's there, other lawyers are there. There's witnesses. It's not like it's in his backyard where no one's around in the middle of the night.
Yeah, that's true, but his wife was there too, right? She doesn't want to sit in a room with this guy. So. And I mean, if you don't want to sit in a room with him and you have this restraining order, you probably, you don't need to. I mean, was there now, like, for instance, in the court hearing where Laura Owens was, she tried to pull this crap with, well, I have a restraining order, so he can't even testify. He can't even be in the same building as me, which ridiculous on its face because we were surrounded by bomb sniffing dogs and security,
and he was ordered by the court to be there,
and he was under subpoena. But in this case, is there a bunch of armed security at this place? How do they know what he's going to do?
It's a law firm, probably not. But I'm just objecting to the fact that they said that he purposely went somewhere where he knew this guy would be, so he went there voluntarily, knowing that he would be there. So clearly, he's not afraid of him, which I think is malarkey, as you youngsters say, because again, whether I feel safe, you're surrounded by lots of witnesses in a neutral lawyer's office with all this other stuff going on is much different than feeling safe in the middle of the night in my backyard when I know this guy's prowling around.
That's true. That's definitely true. The evidence presented is undisputed that the respondent, through counsel, definitively placed the petitioners through their counsel on notice that the respondent would be at the law office location on 2/6/24 at the commencement of and during the deposition proceeding. Either the petitioner's counsel was then negligent or acted intentionally in not advising the petitioners that the respondent, the individual with whom his clients claim ongoing fear of imminent risk of harm, would be at that location. Or, again, with the run-on sentences, they acted in concert to create the environment that would appear to have finally trapped the respondent into a violation of the injunction. He is accusing Randy of setting a trap for this guy.
Yep.
When all other attempts reporting and or claiming such violations were futile. The evidence presented is consistent with the latter scenario.
Yeah. He just accused him of setting him up.
Wow. We've already had to check off judge insults lawyer. I did not have judge accuses lawyer of a crime on my bingo card. All right.
The clear and undisputed evidence. Okay. Let's see.
Was
if
it undisputed though?
Well, we're going to see. Let's see if this evidence he's going to talk about actually is clear and undisputed. The clear and undisputed evidence established that the respondent, who had previously provided greater than 2 weeks' notice of his intent to be at the deposition, had every intent and purpose to avoid any contact with the petitioners and intended to remain in compliance within the parameters of the final judgment of the final judgment of protection under review. All right, so he's saying the respondent gave more than 2 weeks' notice, saying he was there, letting people know who's going to be there, and he intended to comply. Well, that helped.
Sorry.
Intended to comply with the protective order.
What did he do? There we go. Sorry about that.
There we go. So yeah, it's undisputed that the respondent intended to fully comply with the protective order. He didn't come there to violate it.
I don't know why this keeps happening. Hold on. I need to switch a window. Hold on. I forgot. I didn't close down the windows I was supposed to close down, and that's what's causing the problem. Okay. How's that? I need to make it bigger.
Yes. Can you make it one more bigger?
That's what she said.
There you go.
All right.
Now it's even easier for blind old me to see. At best, from the petitioner's vantage point, it may have been their negligence, gross negligence, recklessness, or indifference that led to their arrival at the place of deposition after the respondent and his counsel were already inside the office.
Those are some strong words. Negligence, gross negligence, recklessness. Wow. He's not done.
Nope.
This is still you.
However, when also considering other evidence presented, which includes the fact that the petitioner, William Gosney, called 911 when he arrived in the parking lot of the
911 call, bingo card.
Let's try that again. However, when also considering other evidence presented, which includes the fact that petitioner William Gosney called 911 when he arrived in the parking lot of the office and requested law enforcement to respond to the scene, demanding arrest of the respondent, whom he labeled a felon, which he is not, while the petitioner's attorney audibly can be heard on the 911 call telling the petitioner, "Don't tell them I told you to call," it becomes evident that the near contact on that date was the result of the petitioners, possibly due to their own counsel, not responding to respondent's counsel's inquiry to let them know whether petitioners were intending to be physically present during another fucking run-on sentence.
Yes.
Well, this isn't run-on. It's just really fucking long.
Really long. Too long. Too long sentences can be run-on as well. I mean, that's how it feels when you write a sentence that is so long, even if it's grammatically correct, but it's so long that the person reading forgot what the first half of the sentence was before you get to the bottom. It's too long.
I forgot the middle half, the middle part. Petitioners were intending to be physically present during the deposition scheduled for that day as subterfuge. I didn't use the word subterfuge today, just accidentally. A subterfuge and a trap to trigger a violation of the injunction. Now, I want to go back up to the this "don't tell them I told you to call."
Okay. You want me to scroll back there?
Yeah, just a little bit, yeah.
All right.
There we go. Don't tell them I told you to call. So apparently on the 911 call, you can hear
we listened to that and I didn't hear that. Did you hear it?
I said you can audibly be heard. I didn't hear it. I said, "Don't tell them I told you to call." Now, again, was it, "Hey, don't tell them I told you to call," or was it, "Don't tell them I told you to call"? Either way,
that would make a difference.
Yeah, it's like, "Hey, don't tell them I told you to call," or better yet, does it even matter? If I had a client who had a protective order and they thought someone was violating it, I would say, call the cops.
Right.
I would say that. So,
MG Law says, I'm behind, but it doesn't matter if the judge thinks Randy set up the respondent. The respondent knew there was a chance the petitioner would be there, and he had a legal obligation to stay away.
See, and that's what I'm saying. All he had to do is get up and go, all right, he's here. I didn't know he's going to be here. I'm out, and go to a different room. And
it doesn't seem like that big of a deal.
So even if petitioner's counsel merely forgot the prior notification provided to him and forgot to get back to where you once belonged, to respondent's counsel to advise of the petitioner's decision of what their intended location would be for the deposition, simple logic would dictate that on the morning of the deposition, the petitioners and their counsel would have inquired and or discussed amongst themselves, was there any chance of the respondent being present? After all, the entirety of this case involved the petitioner's desire to avoid claimed imminent risk of harm from the respondent and situation. Again, such an analysis is not to advance that the petitioners had any obligation to avoid the respondent. Well, thank you for acknowledging that basic fact. To the contrary, it was the respondent's responsibility to avoid contact with the petitioners. A correct statement of law. To that end,
I may faint.
The uncontroverted evidence is that the respondent did provide timely notice of where he would be in person on 2/6/24. He did arrive at said location in the company of his counsel. He did not have any actual contact with the petitioners, and he remained inside the office building until being escorted at his counsel's request by law enforcement to ensure all avoidance of the petitioners.
I did not have passive aggressive pause on the bingo card. I shall remember that for next time. Scrolling fuckery and passive aggressive pause.
You are a meathead.
However, in evaluating the petitioner's claimed fear of imminent risk, there is no credible evidence in support of such a claim.
Despite the testimonial evidence presented by the petitioners that they have
Stop
suffered.
laughing and read.
Stop
laughing.
Stop it. Shut up.
You meathead. Didn't I give you a direct order?
We hit buttons at the same time.
Well, I'll hit mine again then.
What about you, meathead? Didn't I give you a direct order?
There we go. Sorry.
Oh, those are good. Despite the testimonial evidence presented by the petitioners that they have suffered serious, ongoing issues with the respondent, which were reported to law enforcement, there was no corroborative and or credible evidence of any violation of the terms of the injunction. What about the fucking recordings? Watch you die, watch you die, watch you die. Credible evidence of any violation of the terms of the injunction, and not one affidavit ever alleging a violation of its terms. Further, despite the respondent having also been placed on 24-month supervised state probation commencing on 1/2021, with the first 6 months being under strict statutory community control conditions, there has never been an alleged violation of the terms of that probation community control. This is especially relevant as the nature of the petitioner's claims involve allegations of threatening behavior and possession of firearms during the relevant time period in which this respondent was under restrictions from both the civil injunction and the criminal court probationary term, which one would reasonably we're still on the sentence is still ongoing.
5, 6, 7, 8, and I'm counting words.
Oh my God. Which one would reasonably expect would result in some form of alleged violation of either the terms of the injunction and or community control and or probation and or new substantive charges being brought? Okay, the thing is, though, when you report violations to the Levy County Sheriff, they don't do jack shit. And we've seen that. It is not credible to conclude, as the petitioner suggests, that law...
May I pause and say
Yes.
that last sentence had 74 words in it?
That is almost a blog post.
Now, Judge DeThomas is, I would guess, maybe 10, 12 years older than me. When I was in law school, if you handed in a brief, anything, an analysis, if you handed in anything that had a sentence longer than 50 words, they would hand it back to you without grading. It was a hard and fast rule in my law school's legal writing that no sentence should ever be more than 50 words, ever.
That 74 words is obnoxious.
It is.
Do we get to check off Judge pontificates yet? I guess that deep sigh is a no. Is that a dog snore or a deep sigh?
That's halfway between a and a.
I thought that was dog snore. For a minute, I got excited.
Well, that's actually what I was huffing over, was whether we should give Judge DeThomas credit for Dick Hard for writing his sentence with 74 words in it.
Barbara, thanks for the Venmo for the 5. Barbara says, for helping me laugh really hard every day with your shows on YouTube. Don't want YouTube to get any. I know not much, but unlimited budget. Hey, that $5 is fantastic. And thank you so much. And I appreciate you for not wanting Google to get their hands on your money. I totally get it. And I appreciate that also. All right. So we have a ruling on Judge pontificates. And it's a no for now. We have a ruling. Jeff's silence was a ruling, which means no. All right. Where was I?
It's not credible.
It's not credible. It's more consistent. Wait.
It's not credible to conclude. Fourth line up from the bottom.
Oh my God, I'm still there. It is not credible to conclude, as the petitioners suggest, that law enforcement continually and repeatedly failed to take appropriate action on their complaints. Is it though? Is it not credible? It is more consistent with the evidence presented that law enforcement concluded that petitioners' allegations lacked even probable cause, or they were too lazy to do anything about it.
Yeah. That would be, again, the judge jumping to conclusions. Another significant and very troubling aspect of the petitioner's testimony, and bearing heavily on the question of credibility or lack thereof concerns, the undisputed evidence presented at hearing that petitioner William Gosney admitted that when he reported an allegation to law enforcement that the respondent threatened to shoot out the petitioner's video surveillance cameras, he lied to law enforcement and did not disclose that he, Mr. Gosney, discharged multiple rounds from a firearm.
Blam, blam, blam. We can check that off now. Multiple rounds from a firearm, that describes blam, blam, blam.
I suppose.
Hey, I'm hosting today. I say you get it.
That's why I said I suppose. You're the knight, I'm the squire. In another instance, evidence was presented involving a report to a deputy breeding of the Levy County. He's dead.
Rest in peace.
Yes. The deputy breeding of the Levy County Sheriff's Office that contradicted the synopsis of events as told by the petitioner. False reports to law enforcement are among the more significant factors that would and do in this instance undermine the credibility of a witness. In this case, the petitioner.
While the petitioners present claims of a continued belief that they remain in fear of imminent risk of harm based on the totality of evidence presented and considered in the light of the credibility and weight to be afforded such evidence, there is no basis to conclude that such belief is objectively reasonable, as it is, at best, their subjective belief colored by bias, he would know about that, resulting from the uncivil behavior between the parties and or the incentive to bolster the ongoing civil litigation between the parties for which monetary damages are being sought. I bet that's 100 words.
How long is
that's one sentence? That is one sentence.
It is. 1, 2, 3, 4, 5, 6. How long that's more? That's got to be more than 74 words. 5, 6, 7, 8.
I have to know.
Oh, great. Well, you count while while I wonder audibly how long this stupid order can possibly go on. This is lengthy.
All right, it's 13 words across and 10 down.
That
10
can't
or-
be 100. That
What?
can't be 100. 5, 6, 7 down.
7 down. Sorry. What's 7 times 13? That's going to give you an approximate word count. I can't do that math in my head. Jeff, it's on
18,
you.
19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 1, 2, 3, 4, 5, 6, 7, 8, 9, 41, 2, 3, 4, 5, 6, 7, 8, 9, 50, 1, 2, 3, 4, 5, 6, 7, 8, 9, 60, 1, 2, 3, 4, 5, 6, 7, 8, 9, 70, 1, 2, 3, 4, 5,
91.
6, 7, 8, 9.
I'd say it's 91.
1, 2,
91-ish.
3, 4, 5, 6, 7, 8, 9, 90 words.
Oh, I was right. If you had just done what I said and did 7 times 13, you'd come up with 91.
But Megan, I counted and or as one word. If you separate it into two, it's 91 words.
So it's perfect.
Could be.
I was right.
You
My
could've been.
math actually worked. This might be the first time in my entire life that a math problem that I came up with actually worked. Do we have like a what? Okay. I can't believe it. I can't wait to tell my husband. He's gonna be so proud.
It worked.
I did math and it worked. I did a math thing. As Florida court, is it my turn? No, it's your turn.
No, it's my turn. As Florida courts have consistently held, it is unfortunate that certain neighbors cannot get along. Have courts really held that it's unfortunate that certain neighbors can't get along? Nevertheless, continuation of an injunction.
Apparently, this is a big problem in Florida.
Apparently.
It's so big of a problem that the Florida courts
They just held it's unfortunate.
They've held this regularly, this conversation.
But I think what they actually did was they've consistently held that a continuation of an injunction, as here, when there is no objective reason to believe the respondent poses risk of imminent harm to the petitioner, is improper. Petitions for injunctions are to be used only to rectify egregious conduct outlined in the statutes themselves. The statutory provisions are not a panacea to be used to cure all social ills. In fact, nowhere in the statutory catalog of improper behavior is the provision for court-ordered relief against uncivil behavior. An injunction is not designed to keep the peace between parties who, for whatever reason, are unable to get along and behave civilly towards each other.
Did you like my scrolling action there?
I did.
Look at that. I did some good scrolling action, didn't I? There was no reason to be pausing.
Scrolling. Keep that Megan scrolling, rawhide.
The evidence presented at hearing established that the circumstances in existence at the time of entry of the final judgment no longer exist. There is no basis to conclude there remains an objectively reasonable belief that there is imminent risk of harm, and continuation of the injunctive relief would serve no valid purpose. Oh, you get to read the actual part, the order part of the order.
Oh, thank God we're done. Wherefore, it is ordered and adjudged that the motion to dissolve final judgment of injunction for protection against repeat violence is granted. So the protective order is dissolved. I am the god of mediocrity. You are dissolved. Sorry, little Amadeus humor there. The final judgment entered on the 11th day of September 2019 in the above styled case is dissolved and terminated this 18th day of April 2024.
Done and ordered. Okay, BK, thank you for the gifted Megan Fox membership. Welcome to the Fox Den, whoever got that. I don't have the studio open in front of me, so I can't tell you who it was, but whoever it is, make sure you thank them. And Jack's mom, this is for you, Jeff.
Thank you so much for being a member for 1 month. I think we need to buy the house next to Grudge and act like this guy and Lynette. We could use his rulings as a defense.
Good Lord.
Blast our music really loud and throw tortoises at him.
120 decibel level.
All right.
Let's see. All right, now somehow this got too big.
That's what she said.
All right.
Your microphone suddenly sounds very hollow.
Really?
Yeah.
Did it fix itself?
No, it's like you've punched some sort of stadium button or something.
What?
I have no idea.
Uh-oh, that's not good. All right. Well, why don't you read while I reset my I'll shut down voice mod. Maybe that's it, and restart it. But I'm going to be mute for a few minutes.
Well, then scroll up a little bit more because we've already read this paragraph.
All right. Where do you want to start?
There, I will read very slowly. Well, I have it over here on mine, so you can just scroll to catch up in due course.
Yeah, I can scroll while I'm doing this. You just won't be able to hear me.
And I literally just said in due course, like I normally write my letters. I'm such a lawyer. In due course. The Gosney's second motion to disqualify for bias arises predominantly from the comments and characterizations made by Judge DeThomasis in his final order of April 18th, 2024, which we just read. So this second motion to disqualify the judge comes from the things that Judge DeThomasis said in that ridiculously long order we just read. In the related domestic injunction case, maligning the credibility, integrity, and ethics of the Gosneys and their attorney, Randall Shockett, Esquire. In doing so, Judge DeThomasis further created the appearance that he prejudged claims and material issues in this civil case. He also violated their due process rights.
Okay, how do I sound?
Perfect.
Okay, perfect.
In addition to the prejudicial statements made by the judge in the April 18th order, certain events occurred on April 12th, 2024, during the afternoon portion of the hearing, which provide further grounds for this motion.
All right, and we have a footnote. We need to go down and read.
Okay.
Number 1, William Gosney, petitioner versus Philip Griffith, respondent.
Injunction.
Final judgment of injunction prohibiting repeat violence entered against Griffith on 9/11/19 by the late Honorable Timothy
Wow.
Browning, R.I.P.
Everybody's dying.
Everybody's dead
The
in this
judge
case.
and
The judge, the cop.
breeding, yeah.
R.I.P. Judge Browning. I heard good things about Judge Browning, so R.I.P. Judge. Is this
Paragraph 2.
2. This motion is filed no later than 20 days from April 12th, the earlier of the two precise dates when the facts constituting the grounds for the motion were discovered, and therefore it is timely under Florida rules. Additionally, in conformity with whatever rule, this motion is sworn by William Gosney and Brenda Gosney, and attorney Randall Shockett has attached his own affidavit in support of the factual allegations concerning himself, because there were a lot.
Judge DeThomasis is presently the presiding judge in 2 cases involving the Gosneys as plaintiffs/petitioners and defendant Philip Griffith as defendant/respondent. This civil case for intentional infliction of emotional distress, trespass, and nuance, and this other case for repeat violence injunction obtained by Gosneys against Philip Griffith involving aggravated assault with a firearm.
No judge has been disqualified from the civil case or the domestic injunction case as of the filing service of this motion. Judge DeThomasis was presented with the Gosney's initial disqualification motion orally and then reduced to writing. On April 12th,
You
2024.
should have said Ore tennis. We could have marked it off.
I think that's coming. Don't worry.
Okay.
Judge DeThomasis was presented with the Gosney's initial disqualification motion orally on April 12th, 2024, in the middle of a hearing on Griffith's motion to dissolve the 2019 repeat violence injunction. Judge DeThomasis denied the first motion, and therefore the legal standard for a first disqualification applies.
Well, the Shockett Law Group / Randall Shockett Esquire represents the Gosneys in both cases, but was not involved in the original injunction case in 2019. Stanley Griffiths, Esquire, and Jennifer Kirchhoff, Esquire, are presently co-counsel representing Philip and Kimberly Griffith, but were not involved in the original injunction case in 2019.
In the injunction case, a live hearing was scheduled before Judge DeThomasis in Levy County for Friday, April 12th, for 60 minutes from 9:30 a.m. to 10:30 a.m. on Philip Griffith. Yes,
I think
it is.
I think that qualifies as a timestamp. I don't know.
It does. On Philip Griffith's motion to dissolve the final judgment of injunction repeat violence, attached hereto is Exhibit 2.
Yeah. In the civil case, a live hearing was scheduled before Judge DeThomas' in Levy County for Tuesday, April 16th, for 4 hours from 1 p.m. to 5 p.m. on multiple motions filed by plaintiffs and defendants.
On Thursday morning, April 11th, Attorney Shockett learned that one of his cases was set as number 1 for a 4-day jury trial commencing 4 days later on Monday, April 15th, my birthday, at 9 a.m. in Broward County, Florida. Attorney Shockett immediately notified Judge DeThomas's judicial assistant, as this trial would clearly affect the 4-hour hearing on 4/16 in the civil case. By furnishing the judicial assistant with the originating email from the Broward court containing all pertinent information for verification purposes, Attorney Shockett indicated efforts were being made to ascertain whether the jury trial could be specially set in early June, and he would confirm once he knew for sure.
Well, the trial court in Broward County ultimately confirmed that Shockett's 4-day trial would begin at 9 a.m. on Monday, April 15th. As instructed by the judicial assistant, Shockett filed and served an urgent motion to continue the April 16th hearing in this civil case.
Addressing Shockett's motion for continuance in open court at the April 12th hearing, Judge DeThomas said that Shockett's motion was denied unless he was notified by email Monday morning that a jury was impaneled. Although preparation for the upcoming jury trial and the 5-hour drive from Alachua County to Broward County consumed all of Saturday and Sunday, the lawsuit was voluntarily dismissed early Sunday evening. Shockett emailed the judicial assistant at 7:07 p.m. He's getting cheeky with his timestamps. That very evening, with a brief explanation of what occurred and that there would obviously be no need to continue the hearing on Tuesday, April 16th.
Oh, I'm sure the judge loved that.
Oh, I'm sure he loved that, being right and everything. Emails referenced herein have not provided as exhibits, as the trial court was already privy to them in real time and has them.
Nonetheless, as of the commencement of the hearing on April 12th, all the way through early Sunday evening on April 14th, Shockett's 4-day jury trial in Broward was fully intended to go forward on Monday, April 15th at 9 a.m.
Given the court-ordered, which is italicized, time limitation of 60 minutes for the hearing on Friday of April 12th, Shockett had no reason to believe that hearing would interfere with the time that he had set aside for the rest of that day to continue to prepare for trial, including, without limitation, necessary pretrial court-ordered conferences with his opposing trial counsel before leaving for Fort Lauderdale to complete preparations from there.
Well, that sounds like a rational, reasonable thing to say. During that whole day, they were still planning on going to trial on Monday in the other case.
I think we can check off calendar fuckery at this point, because this is a whole lot of calendar fuckery going on.
We need to have an intervention about you and your language, young lady.
I'm sure my mother would agree.
That was I remember the first time that I was like sitting in the counter talking to my mom, and I accidentally said shit in front of my mom, and she didn't bat an eye. And I went, "Oh, we're friends." I can swear in front of mom.
I'll never forget the first time I heard my mom swear, because she does not use swear words, and she was very upset about the state of our carpeting, and she was yelling at my dad, and she was saying, and she just like had a breakdown, and she goes, "This carpet looks like shit," and she was trying to get him to replace the flooring, in the house, and that did it. We all of us went like this. We all went, "Oh." Like, mom is serious. She wants new carpeting now. She's had enough, and she got new carpeting.
Yeah, I'm 55 years old, and my 89-year-old father still gets pissed off if I say the word suck or something like that. We don't need that kind of language around here. Anyway, we digress. The hearing actually began at 9 a.m. rather than 9:30, as everyone was physically present. By 10:30 a.m., after 30 minutes over the allotted time, the hearing had not ended and had a long way to go. Attorney Shaka reminded the court that of his upcoming jury trial on Monday, and given these circumstances, expressed his concern about the time needed to finish. The judge merely said, well, we're past that now, and pressed on despite that knowledge.
All right, you may now check off Judge don't care. Judge don't care. Nope.
Nope.
Not even a little.
Not at all.
Shortly before 12 noon, now 2 hours over the allotted time originally scheduled for this hearing, with neither the Gosneys nor their witnesses having testified, that sounds familiar. Judge DeThomas has stated the 60-minute hearing would go on to completion.
I'm Sam Donaldson. The 60-minute hearing will continue.
Oh, maybe Judge lies about schedule. I think we can check that off too. He lied about the schedule.
Oh, okay.
He said it was going to be 60 minutes and it ended up being 8 hours.
Yes. Now, if I can just get dick hard, I'll be happy.
That's what she said.
Look at all the bingos. Look at all the bingos. And
Yeah.
I still don't have bingo. Dang it.
I just, anyway.
Giggity.
Yeah.
Giggity.
Shortly before noon. Oh, sorry, I read that one, didn't we? So go ahead. At that point, shock it. All right, hang on. What have I done? I can't see you. Oh, there we go. I clicked another window. You disappeared. At that point, Shockett made an Ori tennis motion.
Ori
Yay.
tennis. Click that off.
Oral tennis.
Oral tennis.
Made an oral tennis motion to disqualify Judge DeThomas for bias based on certain things occurring in court during the late morning, and requested time to reduce it to writing. After initially refusing the merits of the ore tennis motion by trying to explain away the sudden accusation he made towards Mr. Gosney about recording the proceedings on his cell phone.
Oh, can we check off? Are you recording me?
Why not?
Yes. Why not?
Sure. I'm feeling generous, and it's not my show. So I think that's it. I like that. He refuted the merits of the ore tennis motion, and he tried to explain away the sudden accusation because remember, he's like, "Are you recording in here?" And and he like berated him, and he's like, "Hey, I think we need to recuse." And the explanation was, "Well, my bad eyesight, and it looked like it, and there's other stuff, and you record other things." So he was trying to explain it away so he wouldn't become the subject of a motion to disqualify, which failed because he got the motion to disqualify. So he tried to explain
says
away.
I sound like I'm in a can again.
No.
Oh, okay.
You
Maybe
sound fine
she's
to me.
behind. We forgot to check off Judge interferes in another case, and that gives me bingo.
Oh, I thought we were going to do that when we actually interfered in the case of the next paragraph.
Oh, never mind. Okay.
No, it's your show. We'll give it to you in advance. If you want.
All right. Where are we?
I'm still reading.
Right.
He explained the ore tennis motion by trying to explain away the sudden accusation he made towards Mr. Gosney about recording the proceedings on his cell phone. The judge gave Shockett until 4 p.m. to file the motion, noting he could appear by Zoom to finish the hearing if the judge denied it, which he did. All right, now 16.
All right. In an abundance of caution, Shockett also had ready for filing a notice of intent to file a petition of writ of prohibition, which was very smart, and request for stay to draft, file, and obtain a decision on the writ petition, not yet filed due to preparation and filing of second disqualification motion based on new events after the first motion was filed at 4 p.m. Judge DeThomas even went so far as to check the timestamp on Shockett's notice of intent, saying he needed to make sure Shockett filed his motion for stay after and not before the entry of the order denying the disqualification motion.
Yay. The afternoon session. The hearing resumed at approximately 4:15 p.m. that Friday afternoon. The Griffiths and their counsel physically returned to the courthouse. while attorney Shockett and the Gosneys appeared by Zoom from their respective locations.
Griffith's attorney represented to Judge DeThomasis that his clients objected to any continuance of the April 16th hearing, as they traveled here from out of state to attend the two hearings, 412 and 416, and fully intended to be at the hearing on Tuesday, 416 as well. However, the Griffiths did not attend the 416 hearing, despite their attorney representing that they would be there in person. Griffiths no-show.
Griffiths a no-show.
You can check that off your bingo card. Griffiths no-show. Oh, we got more. Melissa McDonald, congratulations. She got a bingo. Rosalind just said Muppet. Who did Muppet voice? Did Jeff do Muppet voice? I didn't hear it.
I didn't.
We already checked that off anyway because I accidentally did Muppet voice without knowing it early in the stream. I went, okay.
It's that Bert frustrated at Ernie.
Yeah. I forgot who read the last one. Was that me?
Yes. Attorney Shockett reminded the court again of his commitments to his opposing counsel in the jury trial to work with them that afternoon to ensure compliance with the deadlines of their pre-trial order in advance of the Monday trial, and that his phone was literally blowing up with calls from them. Moreover, Shockett informed the court that his time that evening was further limited due to the Sabbath starting in a few hours. See, now this is where I want to give you the judge interferes. Well, he didn't say the word sunset yet.
Well, do we have to go for the word, or do we know what Sabbath means?
Well,
all right, fine.
Yes. All of my Jewish friends are definitely letter of the law above the spirit of the law.
All right. I knew it when I was making the card. I should have put Sabbath on there instead. As the hearing had only been set for 1 hour to begin with.
You've already got your bingo, Megan. Settle down.
That's true. I do, but I'm going for double bingo.
All right.
As the hearing had only been set for 1 hour to begin with, it was clear it would not conclude by 5 p.m. Shockett was aware of another case, also involving a domestic injunction.
He was aware of another case,
where Judge DeThomasis ended proceedings promptly at 5 p.m., expressly stating that requiring court staff to stay until 6:30 at the earliest is not even an option. And then we have footnote number 2. Let's go to the footnote number 2. On November 29th, 2023, at a hearing in Preston v. Hales, Judge DeThomasis said, "I am just not going to have my clerks wait here until after 5 o'clock and my court security." You want to read Mr. Feather?
I just really wanted to cross-examine her, the witness, the only one we've heard from, and I wanted to be present.
And deny her the ability to present the evidence. Ma'am, how long are the videos?
They're like 30 minutes each.
They're like 30 minutes each.
There you go. Okay, 30 minutes, 15 minutes, which is never going to be 15 out of 15, 30? It was never going to be 15 or 30. We're going to be here until 6:30 at the earliest. We're going to have to reconvene, which there's just no option around that. Everyone can check off 15 minutes. 15 minutes. And the excerpt is attached as Exhibit 6. All right, let's go back up here.
Scroll back up.
Shockett's request shortly before 5 p.m. on April 12th to continue the remainder of the hearing to another day, given his other pressing trial commitments of which he made the judge well aware, did not seem at all unreasonable.
Judge DeThomasis, however, I can't not say that now. However, called for a 10-minute recess and then announced that the hybrid hearing would continue until 7:55 p.m. that evening, if necessary, having checked the exact time of sundown in the Farmer's Almanac.
All right, can I have sunset now? Sundown, sunset, and Judge reads Farmer's Almanac.
I thought he checked the NASA site.
Well, so that's the strange thing about this. It sounded like he went to check NASA during the hearing, but in the motion he said Farmer's Almanac. So I don't know. I don't know if he just got it wrong or I got double bingo. Farmer's Almanac gave me double bingo. I'm going for a complete white out now of all of it, or yellow out, as Rosalind says. I'm going for all of it.
Well, if I can check my dick hard, I get an automatic double. I get a twofer. I get a twofer if my dick hard. You know.
What?
All right. Who's
And ironically, lewd act would also give me another one.
Oh my Lord!
I can go 3 times
over the roof.
I
This will
can
get
go
awkward.
3 times with dick hard and lewd acts. You know.
This will get awkward.
Okay. The chat is cracking me up.
Jeff with the dirty bingos.
Dirty bingo. It's not our fault that the facts of this case include all of this shit.
I know. Now I've got like what's her face that played Sissy Spacek's mom in Carrie going, it's the dirty bingos.
Hey Joe, thanks for the 5. Can we drag this out for 6 weeks? I fell over the holiday weekend and broke my foot. Oh no. My palm was injured in the fall as well, and her paw is broken. Aww. That's terrible. And for Jeff?
Don't say oral tennis again. You might summon LO.
I bet LO is really good at oral tennis. It's probably one of her favorite games.
She can fit 2 balls in her mouth at the same time.
Oh, that's what she said. Exactly. All right.
In Cine vi Cabeza. Knock him in the cabeza.
I did not have bad Mexican accent on the bingo card, unfortunately.
The court noted that although a scheduling problem is not in and of itself a basis for disqualification. Damn it, I don't have control. I can't play the we don't need no stinking badges clip. Damn it. The court noted that although a scheduling...
Infamous.
Would you say I have a plethora?
Jefe. Would you say? Oh God. Professional.
Totally professional. The court noted that although a scheduling problem is not in and of itself a basis for disqualification, we remind the trial judge that courts must be reasonable with scheduling and should consider the impact scheduling decisions have on the parties and their counsel, citing Fitzner v. State. The court in Cine made that comment because the trial judge refused to accommodate an attorney's pre-planned out-of-state vacation. Here, DeThomas is not only unreasonably refused to accommodate Shockin for a 4-day jury trial, but made him stay even later, knowing his circumstances. The cumulative effect of Judge DeThomas's manifestations of antipathy and disdain for attorney Shockett in this case and other recent case, Preston v. Hales, including the judge's previous non-existent option to stay past 5 p.m., that was a good one. That was a nice little zinger there. Including the judge's previous non-existent option to stay past 5 p.m. suddenly becoming an option now when Shaka was involved in the case and Judge DeThomas knew he needed to leave, strongly suggests that the judge's bias against the Gosney's attorney is indeed personal and that disqualification is necessary. The appearance of Judge DeThomas's lack of neutrality is staggering.
I think that we staggering, just like Judge DeThomas likes to put his syllables together. Bias. I think we can check off bias. I think it's reasonable to check that off now.
Woo,
and
bingo!
I just got it. Triple bingo.
Woo, I got one.
And also, I think we can check off religious tyranny too, which gives me quadruple bingo. Holy cow.
See. Well, in that case, I think we can check off inappropriate dog toy, dick hard. And
we didn't get to that yet.
As long as we're just making up shit to mark off on the bingo card, I may as well play along.
You don't think that it's religious discrimination and an act of tyranny by the judge to keep him there till the last possible second before sundown? A Jew on the Sabbath. Really?
So long, farewell.
I
Good
disagree.
night, adieu. Oh, sorry. That was a long setup there for that one.
Okay. On April 18th, 2024, Judge DeThomasis rendered an order granting Griffith's motion to dissolve the injunction prohibiting repeat violence. Exhibit 1. The specific comments and characterizations made by Judge DeThomasis in that order about the Gosneys and their attorney, Randall Shockett, are highly prejudicial and incendiary and have created and exacerbated the Gosneys' fear that they will not receive a fair trial before Judge DeThomasis in subsequent pending proceedings. The factual allegations set forth herein are, as a matter of law, legally sufficient basis to disqualify Judge DeThomasis for bias pursuant to Section 38.10.
Get out of here, you bum. Standard for determining legal sufficiency of a motion to disqualify for bias. Section 3810 of Florida statute compels a judge to proceed no further if a party to a case has a reasonable belief that she cannot receive a fair trial because of the bias of the judge. And again, I like the wording of that. If a reasonably prudent person would believe that they can't get a fair trial, then the judge must stop the proceedings. And it's a pretty low threshold, really. The Florida Rules of General Practice and Judicial Administration 233H provides the judge against whom an initial motion to disqualify under subdivision E is directed may determine only the legal sufficiency of the motion and shall not pass on the truth of the facts alleged. So it doesn't matter whether or not there is an actual bias. They only see, is this motion legal or not? That's the only thing they can decide on, not the facts alleged about the bias. The judge shall immediately enter an order granting disqualification and proceed no further in the action. A motion to disqualify is legally sufficient when the alleged facts would place a reasonably prudent person in fear of not receiving a fair and impartial trial.
And now I know why he denies all of these, because he is not a reasonably prudent person. He just isn't. He's an unreasonable person by definition. So of course he always denies these because he doesn't come from a reasonable person standard. The judge must consider whether a party has stated a fear based on the facts alleged and not their truth or falsity. Rogers v. State. Such fear rests in the mind of the litigant, and it is not for the trial judge to say that it is not there. A trial court cannot insert its own views regarding the facts or motivations of the parties, but must review the disqualification motion from the litigant's perspective. The question of disqualification focuses not on what the judge intended, but rather how the message is received and the basis of the feeling. And when he screamed, "Are you recording me?" then Mr. Gosney took that as a personal insult. And so
attack.
An attack. And even if the judge just couldn't see or whatever his excuse was, it doesn't matter. It doesn't matter.
Yep.
He made the litigant reasonably afraid that the judge didn't like him very much.
It's in the eye of the beholder. Specific facts and
Is
precedents.
that another bark? Or is that a cough?
That's a whine.
It's not a dog snore.
It's a dog whine.
A whine.
Yeah.
That's not a snore. I can't believe
Not a
it.
snore.
Like all week, your dogs have not snored. It's like they
I
have
know.
given up sleeping.
They've given up sleeping. Specific facts and precedents supporting legal sufficiency of the second motion to disqualify. The judge's prejudicial statements and characterizations of the Gosneys and their attorney in the April 18th order are legally sufficient grounds to disqualify Judge DeThomasis from both cases. So now we're getting into the new stuff. Here's the new stuff that he said in the order that we just read. That the Gosneys merely lost the hearing on Griffith's motion to dissolve the junction is not why the Gosneys are seeking the disqualification of the Judge Thomases. Rather, the judge's prejudicial statements impugning the Gosneys' motives for desiring to maintain the injunction against Griffith indicates that the judge has strongly and definitively prejudiced Mr. Gosney's credibility in an unfavorable fashion, resulting in the Gosneys...
That says prejudged. Is that the
What did I
same
say?
thing? You said prejudiced, but I mean,
well.
it's sort of the same thing.
Definitively prejudged Mr. Gosney's credibility in an unfavorable fashion, resulting in the Gosneys' fear of not receiving a fair trial in their civil case pending before Judge DeThomasis. Such inflammatory statements penned by the judge himself create a legally sufficient basis to disqualify him for bias. Cummings v. Montalvo.
A judge's statement that he felt a party lied is a legally sufficient basis to disqualify a judge for bias. Parties are entitled to have a trial judge preside over matters involving their credibility in their present case, who has not evaluated their credibility and character in a negative fashion in a previous case, Holmes v. Goldstein. This is interesting. Under Florida law, a judge's statement that he felt a party had lied in a case before him generally indicates bias against the party. Klein v. JRD Management Company.
That makes sense. If you think someone's lied to you, you may be biased against them. In paragraph 11 of his April 18th order, Judge Thomas wrote, Petitioner William Gosney admitted that when he reported an allegation to law enforcement in 2019 that the respondent threatened to shoot out the petitioner's video surveillance cameras, he lied to law enforcement and did not disclose that he, Mr. Gosney, discharged multiple rounds from a firearm. Emphasis added. Further suggesting that there was other evidence supporting the finding that Mr. Gosney lied about his own conduct in 2019 prior to and leading up to the entry of the permanent injunction against Griffith. Judge Thomas concluded that Mr. Gosney had no credibility.
In paragraph 9, the judge makes it abundantly clear that without an actual violation of the injunction or an affidavit of violation having been physically filed with the court, the Gosney's testimonial evidence of having suffered serious ongoing issues with Griffith without more will never be believable in the eyes of Judge Thomas.
I like that argument. That Judge Thomas also tells us that he gave great weight to Mr. Gosney's testimony on this particular subject from 2019, stating another significant and very troubling aspect of the petitioner's testimony and bearing heavily on the question of credibility or lack thereof makes Gosney's fear all the more well-founded.
A trial judge's denouncement of petitioner's character and believability in the prior proceeding was a strong implication that the trial judge would not believe them in future proceedings. Demetro v. Barad. In Demetro, petitioners filed a motion to disqualify the judge presiding over their adoption case because he had also presided over a prior habeas corpus proceeding involving them and stated on the record during the proceeding that they had lied. Granting the writ, the court held that the judge's statement would give rise to a well-founded fear that he would not believe petitioners in future proceedings and had already formed a hostile opinion as to their fitness as parents. But, my question about this, though, Jeff, is here's the difference I see here, is that this happened to them before their next hearing. And so they put in a request to recuse the guy before based on the previous statements. In this case, Thomas used a previous case to make these statements out in his order after this hearing. Does that make a difference, do you think?
Well, I think it's the same principle. That, believing they lied in one case will prejudice you towards their future opinions in the case and other cases that happen in the future. So I think it's the same principle they're relying on. That if you've determined they've lied before, then you either think they're lying now or they will in the future.
Right.
Likewise, in Holmes v. Goldstein, the court granted a writ of prohibition removing the trial judge in defendant's present criminal case, where the same judge who sentenced defendant on an earlier charge after a jury found him guilty made comments during this is in line with what you're talking about here. The past determination of lying.
Oh, yeah, that's exactly right.
Yeah, so in this case, the trial judge in defendant's present criminal case, where the same judge who sentenced defendant on an earlier charge after a jury found him guilty made comments during the sentence hearing clearly implying that the defendant lied during the jury trial. The court agreed that such remarks would create a well-founded fear that the judge would not believe defendant in future proceedings.
Yeah, it's almost like taking prior bad acts and admitting them in court when you wouldn't normally do that in a jury trial. You wouldn't allow that evidence in, prior bad acts, and yet the judge was like using it to make his decision.
Yeah.
Although the formation of a prejudice during and as a result of the party's testimony in a trial does not have to affect the case in which it was arrived at in that manner, it may operate to disqualify that judge from hearing any later or second trial of that case if one is had, or from participating in any subsequent trial in which the party is involved. Brown v. St. George Island. Given that the Gosneys have a pending civil case against Griffith that Judge DeThomasis will decide on the merits after a bench trial, as well as there being a possibility of subsequent litigation in the injunction case depending on the outcome of the Gosneys' direct appeal of the April 18th order, the Gosneys' fear of having their case tried by a judge who does not believe what they say from the outset of the trial makes such fear objectively reasonable. And we have a footnote. See Berry v. State. Successor judge assigned in order to avoid the appearance of prejudgment on remand. The Gosneys' notice of appeal has not yet been filed, as there is a timely motion for rehearing pending, which was filed with the clerk of court and served only on Griffith's counsel at this juncture due to the 15-day deadline for filing such motions. 15 days! I don't have that on the card. I did have it on the card at first because I read that part and I was like, that would be funny. I should put that on the card because people will be like, 15 days? When did that come up? But then I ran out of space for something else that was funnier. Okay. Are we on 34? Yes. Go ahead.
Wait, you read the footnote, right?
I did. So now we're on 34 and it's your turn.
All right. And before we go, I think this would be a good place to mention we've got about 1,000 people watching between our two channels. Should be somewhere around there.
Yes.
Hit the like and subscribe, people. Hit it.
Yes, make sure that you do that. I am currently we've got 662 people watching on my channel and only 375 likes. That's embarrassing. That's embarrassing.
And I've got 453 people with 349 likes. So please do me a super special solid favor and like my stream and then like Megan's stream as well, or vice versa. And make sure you're subscribed to the both of us. Just do it. You won't regret it. If you're here and you're putting up with our shit for the last hour and a half, you need to be subscribed. And also I have a like and subscribe poll set up today, just to remind people to like and subscribe. Today's like and subscribe poll is: a courtroom is a judge's personal empire, a place to berate lawyers, a law school classroom, or for some judges, all of the above. And so far, for some judges, all of the above is winning with 82% of the votes. So there we go.
Funny.
Make sure you just make sure you do the YouTube stuff. Subscribe to both of us, like to both of us. You guys are awesome, and you're super fun to be here. And the best chats available on the entire internet are with Megan Fox and me.
I agree. Best chat ever.
Now knock the shit off and like and subscribe. God damn it. Are you recording? Paragraph 4. Crack the knuckles. Others, because this is a long ass paragraph. The other specific comments contain. I've got 3 of the first 4 words of the sentence wrong.
It's okay.
Let's try it again. Other specific comments contained in the April 18th order, which caused
boring. I'm sorry. I interrupted you like 3 times now. All right. I'm going to shut up now.
I just wanted to hear it. I just wanted to hear if it was possible. Other specific comments contained in the April 18th order, which caused the Gosneys to fear that Judge DeThomasis will not believe anything they say in the future, are follows. So here's a bullet point list of all the things that DeThomasis said in his order, which makes the Gosneys believe that he is biased against them. However, as with other allegations proffered by the petitioners at hearing, this averment is inaccurate and misleading. Next.
Should I read the next one, or are you going to read all of these?
Oh, no, I'm having fun.
Oh,
or
great.
they acted in concert to create an environment that would appear to have finally trapped the respondent in a violation of the injunction when all other attempts reporting and or claiming such violations were futile. The evidence presented is consistent with the latter scenario.
I like your judicial arm waving.
Yeah, I'm trying.
If only it was still on the bingo card.
I would get it vicariously. Next bullet point, the next example of bias. It becomes evident that the near contact on that date, 2/6/24, was the result of petitioners possibly due to their own counsel not responding to respondents' counsel's inquiry as subterfuge and a trap to trigger a violation of the injunction. Next, despite the testimonial evidence presented by the petitioners that they have suffered serious ongoing issues with the respondent, which were reported to law enforcement, there was no corroborative and or credible evidence of any violation of the terms of the injunction. It is not credible to conclude, as the petitioners suggest, that law enforcement continually and repeatedly failed to take appropriate action on their complaints. It is more consistent with the evidence presented that law enforcement concluded the petitioners' allegations lacked even probable cause. And finally, their substantive belief, colored by bias, resulted from the uncivil behavior between the parties and or the incentive to bolster the ongoing civil litigation between the parties for which monetary damages are being sought. They did it for money.
I will also like to respond that was not the testimony that Will Gosney gave. He actually refuted that very well. He said, no, that isn't why. That's why I called the police. I wanted him in jail. That's what police are for when people break the law. But the lawsuit is about the damages. It's not about come on. He refuted that.
Doesn't matter.
Judge just won't believe it. Yeah. From the judge's repeated negative comments, it is clear that not only will he not believe their testimony in future proceedings, but that he will go so far as to assume a nefarious motive or gross negligence on their part, even for something as innocuous as a mere inadvertent oversight of failing to check the status of Griffith's recently opened criminal case online to see if it was still open. Guy has so many criminal cases open, we can't keep up. We can't keep up, and it's not our fault. Judge DeThomasis drew the most negative of conclusions about the Gosneys and their attorney over a simple mistake without giving them an opportunity to be heard on the issue, and imparted ill motive. Did we miss? We missed
must have been buried somewhere in mine.
We missed a footnote.
It was buried in mine.
All right, which statement was it? It was this one. The
evidence presented is consistent with the latter scenario.
All right, read that one, that footnote.
The statement is particularly egregious because the judge assumes once again that Griffith's counsel purported representation that his client was going to be in a certain place at a certain day and time was a certainty. It could easily have been just like it was in this matter regarding the April 16th hearing, that although his attorney said he was going to be there, he still may not have shown
up. So we were at heard on the issue and imparted ill motive based on rank speculation colored by his own bias against the Gosneys and their attorney, which is palpable. Ethan Shapiro raises his head in this case. His favorite word.
It's palpably Floridian.
It was palpable. It was palpable. It was palpable. I haven't done Shapiro voice in a while. Your Honor, it was palpable.
In addition to the sheer number of negative comments made by Judge DeThomasis about the Gosneys' credibility in a single 13-page order, the judge also cast a number of extremely negative aspersions on their attorney, Randall Shockett Esquire. And just as he did to Shockett and other attorneys in Preston v. Hales, adjudicated his credibility without ever giving him an opportunity to be heard. Shocker. Paragraph 7 of the April 18th order, for example, states that the evidence is consistent with a scenario that they acted in concert to create the environment that would appear to have finally trapped the respondent into a violation of the injunction, when all other attempts reporting and or claiming such violations were futile. Such strong incendiary language in the April 18th order not only has the effect on the Gosneys, causing them to fear they won't be treated fairly because the judge's overt hostility towards their attorney, but it also has a similar effect on Shockett, who was just joined on April 16th as a party to count 5 of Griffith's civil counterclaim for abuse of process, the outcome of which Judge DeThomasis appears to have already adjudicated in his April 18th order.
Negative findings implicating Attorney Shockett's credibility require disqualification of Judge DeThomasis from both of the Gosney's cases. A judge should disqualify himself in a proceeding in which the judge's impartiality might reasonably be questioned, including, but not limited to, instances where the judge has a personal bias or prejudice concerning a party's lawyer. Lohman v. Racetrack Petroleum. A trial court's prejudice against an attorney may be grounds for disqualification when such prejudice is of such a degree that it adversely affects the litigants. Jimenez v. Ratine.
And this next line is exactly why I hate justified margins.
Yeah, that is really shocking. It really is. It's shockingly bad.
I hate
word
justified
placement
margins with a passion. Although an adverse ruling is not in and of itself a basis to disqualify a judge, when the judge's statement casts aspersions on the credibility of counsel for a party, that party's expression of fear that it will now not receive a fair trial before the judge is reasonable, well-founded, and requires disqualification. Cumulative effect of the judge's statement in order sanctioning litigants' counsel held sufficient to place a reasonably prudent litigant in fear of not being treated fairly in the future proceedings by the same judge.
In Samra, it did not matter that the judge would soon be leaving the division such that the disqualification issue would become moot. The court determined that reassignment to a new trial court judge was necessary under the circumstances, which included 1, statements in the written ruling detailing egregious misconduct by Samra's lawyers, and then we have a footnote. In Samra, there was a 2-day evidentiary hearing on a sanctions motion against Samra's lawyers, who had already withdrawn from representing him by the time of the hearing. The judge's sanctions order also mentioned that the judge concluded Samra was, at the very least, aware of the misconduct his former attorneys engaged in. The cumulative effect of the judge's statements in the order were held to be sufficient to place a reasonably prudent person in fear that he or she would not be treated fairly in future proceedings. Oh no, does it continue down here? Before this judge. Okay. Then we have to go up here. Number 2, due process issues because Samra and his new attorney were not permitted to attend the 2-day sanctions hearing. Oh, wow. Really? And 3, prejudgment by the trial court of a motion to strike Samra's pleadings because the allegations set forth in that motion overlapped substantially with the allegations in the prior sanctions motion. This sounds like an interesting case, doesn't it?
Yeah.
Against Samra's former law firm. And the judge already held an evidentiary hearing on the sanctions motion, already made findings of egregious conduct, and already granted sanctions relief. Wow.
It's a lot to absorb.
That is a lot to. That sounds like one we should read sometime. It sounds interesting.
Similarly, in granting writs of prohibition in 3 consolidated cases, the court held the trial court's denouncement of petitioner's counsel's character and believability in a prior proceeding was a strong implication that it would not believe the petitioners in future proceedings. That's interesting. So saying you don't believe if you question the counsel, the lawyer's character in a prior proceeding, the implication is you won't believe the actual party that's being represented by this counsel in future proceedings. In 2 of the 3 cases, law firm represented the client's interests, while in an unrelated case, the law firm itself was a party. In that unrelated case, the judge issued a scathing sanctions ruling against law firm for lying and deceitful conduct.
Liar!
Including participating in a scheme to bring fabricated criminal charges, fully recognizing that an adverse ruling in and of itself is not a biases for disqualification. The court nonetheless held that the judge's statements contained in her order that she felt law firm was deceitful were sufficient to create a well-founded fear in law firm's clients that they would not be believed or trusted by the judge.
And in this case, the judge accused Randy of setting up the the petitioner, setting up Griffiths to be arrested. He accused him of this egregious behavior. The evidentiary hearing underlying the April 18th order had nothing to do with sanctions. It was a motion to dissolve an injunction. In his order, however, Judge DeThomasis incorporated highly prejudicial statements impugning Attorney Shockett's credibility and integrity, stating, or they, referring to the Gosneys and Shockett, acted in concert to create the environment that would appear to have finally trapped the respondent into a violation of the injunction when all other attempts reporting and or claiming such violations were futile. The evidence presented is consistent with the latter scenario. It becomes evident that the near contact on that date was the result of the petitioners, possibly due to their own counsel, not responding to respondents' counsel's inquiry to let them know whether the petitioners were intending to be physically present during the deposition scheduled for that day as subterfuge and a trap to trigger a violation of the injunction. I can't believe we have to read these words again. At best, their subjective belief colored by bias resulting from the uncivil behavior between the parties and or the incentive to bolster the ongoing civil litigation between the parties for which monetary damages are being sought.
Well, Judge DeThomas's April 18th order openly accuses and indeed finds that Attorney Shockett intentionally engaged in some sort of conspiracy with his clients to set up Philip Griffith for an injunction violation, to bolster their position in the injunction case and to bolster their civil case for money damages. That statement is more than inflammatory. It is repugnant and not much different than the Florida Supreme Court's characterization of the attorney's conduct in Florida Bar v. Adams as constituting a deliberate and malicious effort to place a heavy finger on the scales of justice for the sole benefit of themselves and their client, and for which those attorneys were disbarred. There should be no question that if this is what Judge DeThomasis thinks of Attorney Shockett, he should not be presiding over this case, but should recuse himself so that a successor judge who has no predispositions against the attorney can fairly adjudicate the merits of the pending matters impartially. Judge DeThomasis has clearly signaled that impartial adjudication on the merits of the Gosney's pending claims will not happen with him presiding over their case.
Even when merely speculating about an alternative hypothesis for what was nothing more than an inadvertent breakdown of communication between law offices regarding the manner in which the parties would appear at Mrs. Griffith's deposition, Judge DeThomasis chose terms with legal malpractice significance to use against Attorney Shockett, such as negligence, gross negligence, recklessness, or indifference. The judge's obvious disdain for Shockett has caused him to elevate a simple lack of communication into a cause of action for failing to use due care. And by the way, that precipitated a bar complaint against Randy and Doreen by the opposing counsels. So the opposing counsel basically took the judge's words and then filed a bar complaint against Randy and Doreen, which was thrown out. But I mean, that's because of what the judge said. Instead of just being like, you guys didn't communicate well. Can we move on?
Right.
He could have.
He could have. But he didn't. As disqualification is considered from perspective of the litigant, not the judge. If a judge's conduct during trial gives a party reason to believe that the judge is not neutral about him or that his lawyer is deceitful or unethical, he would be a fool if he does not fear that the trial will be unfair. Fear is all that's required under the statute, Moskowitz v. Moskowitz. For purposes of disqualification for bias, why are you laughing? I just had like Coming to America, the Philly Moskowitz thing.
Yes, that's right. There is no appreciable difference between a judge's hostility toward a party or their attorney. And that's in Hayslip v. Douglas.
Sorry, my brain just goes to weird places.
Wasn't the cartoon one Moskowitz?
Yeah, it was Philly Moskowitz was his name.
Moskowitz, yeah.
Yeah. The April 18th order also raises due process issues. Because Attorney Shockett was not on trial, nor did the underlying hearing have anything to do with sanctions for discovery or other litigation misconduct against an attorney. Yet, in his order, Judge DeThomasis condemned this lawyer's ethics, character, and integrity in the context of what was supposed to be a 1-hour hearing on a single issue of whether to dissolve the repeat violence injunction against Griffith.
A judge shall disqualify him. An American Tale, yes, that's it. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party's lawyer. That's in the judicial canons. And I can't. Berger v. Hurley. This case is now the second case in a row, and now we have a footnote, where Judge DeThomasis has gratuitously denigrated Attorney Shockett's character and ethics in the context of a hearing convened merely to resolve narrow factual disputes between parties. Let's skip down to the other case is
the Jeremy reference.
Preston v. Hales. This case is now the second case in a row where Judge DeThomasis ambushed Attorney Shockett by taking on the proverbial role of judge, jury, and executioner to impugn him, his motives, his character, and his integrity without any notice that the judge intended to place his ethics on trial, and without giving Shockett any opportunity to defend himself before condemning him in a written order. A separate affidavit. Remember when he wouldn't let Randy defend himself, and he was like, no more questions, no further questions. A separate affidavit by Randall Shockett, who is now a party to the civil case as of April 16th, is also attached here too in support of this disqualification motion, particularly as this issue is apparently now becoming a pattern with this judge.
Judge. All right, let's get into some deep dive in here. Portions of the April 18th order dissolving the injunction in the 2019 domestic case create the appearance that Judge DeThomasis prejudged issues and claims in the 2023 civil case. The appearance that a judge has prejudged a case without hearing evidence is a legally sufficient basis to disqualify a judge. Cates v. Sindeman. Disqualification is necessary when a judge appears to decide issues in one case based on evidence heard in a prior case. Irwin v. Marco, writ granted where comments during a temporary support hearing created the appearance that judge had prejudged wife's claim for rehabilitative and permanent alimony, which were not before the court at the hearing for temporary relief.
While comments made by the trial judge may not have been intended by the judge to reflect on his beliefs as to the merits of the underlying claims, the standard is the reasonable effect on the party seeking disqualification, not the subjective intent of the judge, Haas v. Davis. Judge DeThomas's gratuitous, prejudicial comments attacking the character and credibility of the Gosneys and their attorney mandate his disqualification from both of the Gosneys' cases.
I agree. So he's not just talking about this one case. Now he wants the judge off of both cases. So I think that is very, very reasonable under the circumstances. Mm-hmm. So the appearance of prejudgment of Gosney's civil claims for intentional infliction of emotional distress. The allegations in the Gosney's 2023 civil claim for intentional infliction of emotional distress overlap with their reasons for keeping the injunction prohibiting repeat violence against Griffith in place. Judge DeThomas's April 18th order foreshadowed his ruling on the civil claim for intentional infliction of emotional distress based on the testimony and evidence presented at the hearing on April 12th in the domestic case on Griffith's motion to dissolve the 2019 injunction against repeated violence.
Specifically, the judge diminished and downplayed the Gosneys' fear of Griffith and emotional distress from Griffith's conduct by characterizing their experiences with Griffith as nothing more than uncivil behavior between neighbors who can't get along. Far from impartial, Judge DeThomasis even offered his gratuitous opinion, assailing the Gosneys' continued fear of Griffith as being incentive to bolster the ongoing civil litigation between parties for which monetary damages are being sought, stating that injunction petitions are only to rectify egregious conduct outlined in the statutes before dissolving the 2019 injunction against Griffith indicates The Judge Thomas has found no egregious conduct by Griffith toward Gosneys, and as such has prejudged the element of outrageousness required for the Gosneys to meet their burden for their claim of intentional infliction of emotional distress in their civil case. That's right on. That's absolutely true.
Yep,
he has
absolutely
prejudged it. He cannot possibly sit on the civil case. No freaking way, man.
I completely agree with that. I got nothing else to add. You're right. In paragraph 6, 7, and 8 of the 18th April order, Judge Thomas maligns attorney Shockett's ethics and integrity, suggesting that he acted in concert and engaged in subterfuge with his own clients to trap Griffith into violating the injunction.
As abhorrent as those statements are generally, they also signal that Judge Thomas has prejudged Griffith's abuse of process claim, which presently includes Shockett. There is significant overlap between the allegations in Griffith's civil count for abuse of process and the judge's statements in paragraphs 6, 7, and 8 of the April 18th order dissolving the injunction. Both concern an incident at Kimberly Griffith's deposition in the civil case on February 6th, where the Gosneys, as well as Philip Griffith, appeared in person, at least initially. In paragraph 34 of his counterclaim, Griffith accuses the Gosneys and Shockett of working in concert to have the injunction against Griffith violated. Such language is eerily similar to that in paragraph 7 of the April 18th order, in which Judge Thomas wrote that the Gosneys and attorney Shockett acted in concert to create the environment that would appear to have finally trapped the respondent into a violation of the injunction.
There can be no doubt that in paragraph 7, 8, and 11, Judge Thomas exonerated Griffith on the merits of his criminal case related to the February 6th incident. Even though that case had been recently closed, as noted by the judge himself, and not under Judge Thomas's jurisdiction. Nonetheless, the April 18th order makes it clear that Judge Thomas not only found Griffith not guilty of violating the injunction, but held the Gosneys and Shockett responsible for the incident, and improperly accused them of engaging in a conspiracy to trap Griffith into a violation. These types of incendiary, inflammatory, prejudicial comments from the judge absolutely cause the Gosneys to fear that they will not receive a fair trial, and that Judge Thomas should not continue to preside over this case. So for Judge Thomas not to recognize that, improper emphasis. For Judge Thomas to not recognize that impugning the Gosneys and their attorney's character and credibility, as he did in this order, as a reasonable basis for his disqualification is not only incredulous, but likely violative of the Code of Judicial Conduct, which requires a judge to be neutral and impartial. The express language used by Judge Thomas in his 18th order indicates that he is not at all impartial or neutral in this case.
Denial of due process is a valid basis for disqualification of a judge. Bailing v. Bailing. Judge Thomas violated the Gosneys' due process rights when he made a precipitous finding. I love the word precipitous. It's fun to say. It's like the name Felicity. Precipitous. Felicity. It's just something that I like to say. Made a precipitous finding. Say it out loud, people. You'll like it. Try it. That they and their attorney acted in concert to trap Griffith in a violation of the injunction. For whatever reason, Judge Thomas put Griffith's attorneys, who advanced the abuse of process claim against Shockett and not exactly neutral, under oath for their side of the story, but didn't allow Shockett the same opportunity to defend himself against such vicious allegations. No, he didn't.
Good point. He also violated the Gosneys' due process rights and exhibited partiality towards Griffith when he allowed Griffith to use the Fifth Amendment privilege against self-incrimination as both a sword and a shield. The judge permitted Griffith to remain silent and not offer any testimony in his own behalf at the hearing on April 12th, even though it was on his motion to dissolve an injunction order against him. And even though Judge Thomas himself pointed out in the order that there were no longer criminal charges pending against Griffith, such that there was no reason for him to invoke the Fifth Amendment privilege. Moreover, despite allowing Griffith to remain silent in his civil action, he declined to draw any adverse inferences against Griffith from questions related to the injunction posed at his deposition in 2023 civil case, where Griffith repeatedly invoked the Fifth Amendment to avoid answering those questions.
You may now check off I plead the fifth on your bingo cards. That
I
has
got the
given me
second bingo.
quadruple bingo now. I'm at 4 bingos. I only have 1, 2, 3, 4, 5, 6 squares left, and then the whole card will be full.
And I've only got 2 bingos.
I'm having a lucky day on bingo today. It took me until yesterday to even get 1 bingo during this
you got a dry
entire
spell.
thing. It was a long dry spell, and now I'm winning and winning and winning. It just keeps happening. Although the law is well settled that a plaintiff is not entitled to both his silence and his lawsuit, and then we have a footnote,
Case site,
which is just a case citing. Okay. Although the law is well settled that a plaintiff is not entitled to both his silence and his lawsuit, Judge DeThomas has allowed Griffith, the moving party with the burden of proof, to have both his silence and his relief. Judge DeThomas has thereby deprived the Gosneys of the ability to fully and properly defend Griffith's motion and thus deprived them of due process.
Furthermore, although argument on Griffith's invocation of the Fifth Amendment privilege and concomitant sword and shield tactics comprised a substantial portion of argument at the hearing, Judge DeThomas didn't address that critical issue even once in his order. Regardless of whether such a mission was merely an oversight, does not at this point ameliorate the cumulative effect of the many prejudicial statements penned by Judge DeThomas, maligning the character and credibility of the Gosneys and Attorney Shockett by imparting nefarious conspiratorial motives to them. Not to mention the one-sided, unbalanced manner in which the judge arrived at these prejudicial conclusions, as well as the judge's overly protective and almost deferential demeanor displayed towards Griffith.
Judge DeThomas's negative and inflammatory comments and characterizations of the Gosneys and their attorney in the April 18th order clearly show that the high level of animosity between the judge, the Gosneys, and their lawyer is not merely because of an adverse ruling, which may be remedied on appeal, but something more deep-rooted that is now finding its way across cases involving unrelated parties. I love this sentence because this is truly what is happening, and it's so obvious.
Mm-hmm.
The judge's prejudicial and inflammatory statements about the Gosneys and Attorney Shockett contained in the April 18th order create an objectively reasonable fear that Judge DeThomas will not treat the Gosneys fairly in subsequent proceedings of any kind before him, and his disqualification from both the domestic injunction case and the 2023 civil case is absolutely required. Carrington v. What? Carrington?
Mortgage.
Never mind.
Mortgage Service. See, Carrington Mortgage Service, LLC. Super.
Okay.
Wherefore, William Gosney and Brenda Gosney request that this court grant their second motion for disqualification pursuant to Section 38.10, Florida statutes, blah, 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 and enter an order disqualifying Judge Craig DeThomas from the above captioned case and allow a successor judge be appointed to preside over the Gosneys' remaining pending matters, including subsequent matters that may arise in the injunction case, in the event Gosney's direct appeal results in remand. The end.
And we can see that Doreen Inkleys is the one who wrote this motion. I really do like the way that Doreen writes. Very clear, very concise, very few of the large words. That
No 91 word sentences.
No 91 word sentences. And then we have the affidavits that all these things are true according to the litigants, certification of good faith, and all of those things. And then we have a bazillion exhibits.
Yes. Many of which we reviewed in the preview of this entire series.
Did we?
This is the one where we went through all of the timeline of things we skipped around in the documents.
Oh, did
like
we
on
do
day one?
Did we read the affidavit of Randy? Did we read his affidavit yet? I wonder if it has any.
It'll just repeat everything that was.
It'll just repeat everything that we already heard. Yeah. Yeah, it does pretty much.
Well, spoiler alert, Judge DeThomas has denied this motion.
Oh my God, you're kidding.
Yeah, I'm in shock.
What?
which prompted what we'll be looking at tomorrow in perhaps our final installment for a while. Maybe, perhaps we'll have to see the motion for the what the hell is it called?
The writ of prohibition?
Yes, the writ of prohibition. That's what we'll be reading tomorrow.
Okay, excellent. And that will be on Jeff's channel. Well, it'll be on both, but Jeff will be hosting, and it will be at the same time, 9 a.m. Be back here, same bat time, same bat channel, and we will go over the writ of prohibition that was submitted to the appellate court, and maybe, if we have time, the ruling from the appellate court, because that's been done. Do we have that? Yeah.
It has?
It has.
Has it?
Yes. I just need to get my hands on it. If I haven't given it to you, I need to get it. But there was a ruling. I don't want to give any spoilers away.
No spoilers.
So there was a ruling, so we have that to go over. And there's something else too. Anyway, I'll figure it out. We're going to have a new bingo for tomorrow. So I'll have to we'll have to look over the whatever's coming up next, the writ of prohibition, and see if we have
Megan
different
is the
squares.
official bingo god. She's the Lord of bingo.
I'm going to make you do it this time. I think I should make Jeff do the bingo.
There'll be no bingo card to make people.
Oh, you know what? I did promise you. Let's take a little before we leave. Maybe we should.
Do you have time?
Yeah, it's 11. I do. I have time. Well, I'll tell you what. Here's what we do. When we end this stream today, I'm going to play for you DJ Radis's new song about the basement pancakes, because it's really funny. It's really funny. For Jeff, we have a super chat here.
We do. Cool. Warrior Biatch. Thanks for this. Takes my mind off my mother-in-law, Alzheimer's.
Agreed. And for Jeff, come on, chat. What's going on, chat? The super chat wars I'm losing today. This is my fault for saying I didn't need any super chats today. This is all my fault.
Thanks for putting Shapiro's voice back in my head, Megan. The effect of such an action is palpable.
It's palpable. You're welcome. You're welcome. Ethan Shapiro was one of my favorite characters in the Maya Kowalski case. And he talked just like this.
When do you have to be with Viva?
12:30.
Oh, 12:30 your time. Okay.
Yeah.
You said 12:30. That 12:30 my time. I'm like, that's like 15 minutes.
No, 12:30. But I do need to do a little bit of prep for that, because I need to
find out what Russia's all about.
Yeah, I need to read the Russia article at least. Actually, I probably won't. I'll just let Viva tell me about it, and I'll respond.
You'll pretend you know everything about it.
I will pretend that I know anything or care about a Russia conspiracy, which I don't. I've given up on politics completely, especially during election years now. I try to check out entirely until the whole damn thing is over.
Yeah.
You know, it's just not, it's not pleasant. But that's okay, because he's going to talk about we're going to talk about the thumbnail lawsuit, which is hilarious. And I can't wait to hear Viva's take on that. I really can't. Jeff, you got any guesses on what Viva's going to think about the thumbnail lawsuit?
I oddly think he's really not going to care.
What do you mean? He has a YouTube channel, a Rumble channel. He uses thumbnails all the time. What do you mean he's not going to care?
Well, he's going to. I didn't ask you, Strawberry. Just give me a minute,
Man, next time I'm putting dog barks on the bingo card. And then
all
we will get is dog snore.
Yeah, that's exactly what's going to happen. I'll just tell you right up front. But anyway, he'll just say it's all BS, because it is.
K-Matt Red Queen, thanks for the super chat. Hair and breast stick money. Breast sticks? Do we have, what are breast sticks? I'm hoping that's a typo.
I'm not.
Thank you for the breast stick money. I'll take it, whatever it is for.
Well, see, I was gonna come bearing whiskey and breadsticks today, but like the bakery that sold the breadsticks, they were awful. They were terrible breadsticks, so I threw them in the garbage.
Oh no! Were they as bad as the double cheeseburger?
Well, that wasn't terrible. It was just a major letdown, and it wasn't worth $10.
The $10 double cheese burger.
Yeah. Stupid
You
place.
got to read the fine print, Jeff. You know, we can.
Or just read it with different inflections, one of the two.
Oh, God. Well, thanks for tuning in today, folks. Today's been a lot of fun. If you are not subscribed to Legal Vices, you need to get over there and do that. Legal Vices has wonderful, great programming, especially Fuck It Fridays. You need to show up for that because Fuck It Fridays are hilarious, especially with the new Temu shopping sprees. I can't wait for you to have your unboxing day when you open up the Screaming Pickles and the mini ducks and the blanket with my face on it or Nick Cage's face. We're not sure which one's going to come on there.
Should be about 2 weeks from now.
Oh, that's so exciting. Jinver, are breast sticks pointy? I don't know. BK, thanks for the 5. I appreciate that. And I think that's it. Jeff, what do you got going on? Anything else besides what we're doing here and that you want to let people know about?
This and then this is it. We'll see you here tomorrow, but also Friday evening U.S. time. Danny on Direct, Flux, and I will be doing another installment of our Unexplained stream, where a good friend of mine who is a ghost hunter and a Bigfoot hunter, and also possibly a medium, will be joining us. And I can't help but notice my Godzilla poster is sideways for some reason.
That's weird. Did you turn it sideways, or did a ghost do it?
Probably the wind, but we'll see.
All right. Well, as we leave, we will leave you with DJ Radis's newest song. It's the not this one. This is the wrong one.
Today, ladies.
Here we go. Scrambled pancakes with ketchup and syrup. Are you ready for this? This is going to be.
Oh wait,
great.
I have a question.
Yes.
I didn't actually. I just look. My mother's mother was a chef in Chicago and Nevada.
Ooh.
My father's mother was a baker for 60 years. My mother was a baker, a chef, and a confectioner. I must admit, I couldn't get to the end of the protein pancake making video. I had to bail when he was like chopping it up into cubes.
The chopping.
He chopped it into cubes and then like reformed it into a pancake about the 3rd time, and then I just had to bail on it. Did he actually put ketchup and syrup on it?
I don't know. I don't think so, but I never made it to the end of the video. So actually, he might have. I don't know. I'm not sure because I didn't make it to the end either. So I guess we're gonna have to find out. I think though that this may be some what's the word I'm looking for? This may be creative license.
I doubt it, but we'll see.
All right, and after this, it looks like I'm going to be sending you over to Lauren Knighty. She's got a breaking stream about some body cam footage in the Tonsil Twins case. So I'm going to be sending you over there. Please tell Lauren that we said hello. And on our way out here, let's enjoy Scrambled Pancakes with Ketchup and Syrup by DJ Radis. And when I say enjoy, I mean try not to throw up.
Today, ladies and gentlemen, I have a special treat for you. I'm going to be cooking my favorite breakfast recipe that has been passed down from generation to generation. Scrambled pancakes with ketchup and syrup.
Oh, God! He does.
In a basement where the light barely shines, Slug Entertainment's got a brand new grind on a folding table. Mom's laundry in the air. He's cooking up a storm like you just don't care. Whiskey next, flipping batter, don't you dare blink. Scrambled pancakes, this ain't what you think. Ketchup in one hand, syrup in the other. Gonna make a meal that'll shock your mother.
What the hell was that he just put in there?
I don't know.
Scrambled pancakes, ketchup on top. Filming for the two, never gonna stop. Syrup drizzle, make it nice and sweet. In Mom's basement where we cook and eat.
Mom's where you can eat. Oh.
Camera's rolling. He's the king of the scene, cooking gourmet, though it's far from clean. Stains on his shirt, but the view's rolling in. Slug Entertainment knows he's gonna win. Takes a bite, pulls a face, it's the truth. Ketchup and syrup, a mix so uncouth. But hey, this is art, it's all part of the show. In the basement kitchen, anything can go.
Oh, the chopping!
Pancakes, ketchup on top. Filming for the tube, never gonna stop. Syrup drizzle, make it nice and sweet. In Mom's basement where we cook and eat.
that Twitter chef that like reviews things and just says fuck
Here's
at the
to
end.
the trees
Yeah, I
and
need
bases
that guy.
below. Cooking up chaos with the
0
lights
out of
at the
10
low.
would
It's
try.
not about
Yeah.
taste, it's all about fame. Scrambled pancakes in the YouTube game. So hit that subscribe and ring the bell. Slug Entertainment's got stories to tell, from the basement kitchen to your online stream. Scrambled pancakes, living the dream.
Oh.
Dream.
The way he makes his pancake, I don't even think he even knows what Japan is.
Yep.
Today, lady.
And that's it. That's it. That's all. I hope you kept your breakfast down. Wow. I got no more words. We got one more super chat though. Matt Right Queen, thanks for the 5. Was to be breadstick, but we can call it for the Lego insult for child gauntlet. Okay, sounds good. All right. Goodbye, everybody. Have a wonderful rest of your day.